Good evening. This is John Milburn for Laws 12066 Land Law. This is week 10. We're dealing with week 8 material, social housing. Now, the good news is that this is non-assessable as far as your examination is concerned. This is an area of particular expertise of Dr. Nankaro, who wrote the notes, and I must confess that Dr. Nankaro knows much more about this content than I could ever profess to know. So I won't be including it in the assessable material. But we're going to talk about 2 acts tonight. Before I do, just a quick note that I am well advanced in marking the second assessment, and I do hope to release the results tomorrow for that assessment leading into the examination. All right, are there any questions before I start? All good? All right. So week 8 material, social housing. You'll see in the study guides that there are a number of objectives that we hope to achieve as a result of this study. It is in 2 parts. The first is to do with the Housing Act and the second to do with residential tenancy agreements. So focusing on some of the terms, social housing means effectively government-assisted housing, financially or provision of dwellings. And social housing landlord is usually a housing community provider, such as community housing provider, community-based not-for-profit organisations, and a social housing tenant, of course, is a person who occupies the premises and deals directly with the community housing provider, which is funded through some form of scheme. So it is a semi-autonomous arrangement, effectively. You would have read in your notes the Housing Act 2003, Queensland, was amended substantially in 2013, which brought it into line with the national law. And those amendments were passed in 2013, which was subject to the national system being up and running on the 1st of January 2014. Now, in the Housing Act 2003, I'm simply going to ask you to consider the main objectives, which is in section 4 of the Act, to improve access to Queenslanders to safe, secure, appropriate and affordable accommodation, and to build sustainable communities. There has been a trend over the years for community housing to be integrated, if that's the right term, into those suburbs that were traditionally not seen as providing social welfare housing. So as to get away from a feeling that if you live in this suburb, it's likely that you're part of community housing entirely, so that there's an integration. Section 5 deals with how the objects are primarily achieved, and they are A, housing-related activities are carried on by the state by providing public housing and housing services and developing, undertaking and supporting other housing programs and initiatives. So that's the first of the objectives. And the second is by introducing a system for supporting and regulating certain types of entities that provide the housing services. And that's done by registering those entities, providing them with financial assistance, and then, of course, regulating how they provide the housing services using the assistance that's provided to them by the government. In operating, the housing providers need to consider and follow the guiding principles. Have a look at section 6 of the Housing Act in that regard. So the way in which the Act must be administered relies on having regard to a number of principles. The first, the availability of safe, secure, appropriate and affordable housing, which is part of the objects, in such a way that it enhances the quality of the life of the people living within the community, and we mean that in a broader sense, and contributes to the well-being of the community by enabling people to participate in social and economic life, which really goes to this integration concept that I was talking about before. That's the first of the guiding principles. The second is the need for safe, secure, appropriate and affordable housing that can be met by entities from government, industry and community. acting separately or in partnership. The third is a community is sustainable if it's socially and economically diverse, cohesive, resilient and adaptable, and has access to appropriate services and amenities. That's a little bit like the concepts that we see in environmental law, where when we're talking about environmentally responsible activities, we talk more than just the environment. We introduce commentary in relation to economic and social activities as well as pure environmental activities when we're talking about this concept of environmentally sustainable development, ESD. Now, the fourth objective or principle of the Housing Act is that housing services should be provided in a way that responds to diverse and challenging needs of individuals, families and other households. So of course, it's quite obvious, I guess, that whilst there are many people in community housing that are perfectly capable of functioning in every way as well as other members of the community, there is a group that needs special assistance, whether it's as a result of disability, physical or mental health issues, or some other form of challenging situation for them. The housing services that need to be provided under the Housing Act need to respond to those diverse and potentially challenging needs of individuals. The fifth principle is that the state provision of housing services should provide leadership, promote best practice in housing provision and residential development, and be integrated as far as reasonably practicable with provision of other government services. The sixth principle, individuals be provided with housing should have access to appropriate choice of housing types and tenures, which of course begs the question as to, that's all very well to have the appropriate choice of housing types and tenures, but how are we going to fund this? And there's a mixture of housing that is, if you like, Green Street, which is built on small lots, high rise, where we're talking about vertical integration, or the larger properties. But do we really see housing which is aimed at the semi-rural market? In my experience, probably not. It tends to be more an urban situation. And partly that might be in response to the transport needs, the school needs and the hospital needs of the participants of the social housing activities that are provided. The seventh principle is that housing services be provided in a way that has appropriate regard to local and regional differences, cultural diversity, and Aboriginal tradition and island custom. And finally, principle is the needs, views and interests of consumers of the housing services need to be taken into account, both in terms of government policy and the way in which non-government entities and industry bodies administer the housing. All right, so that's all I propose to talk about in the context of social housing under the Housing Act. And we now move to residential tenancies. Now, of course, the primary legislation for residential tenancies is the Residential Tenancies and Rooming Accommodation Act 2008, formerly the Residential Tenancies Act, administered by the Residential Tenancies Authority. And this piece of legislation is quite broad-reaching in that it deals with the way in which tenants and property managers or owners deal with residential renting. That includes caravan parks, and as the name of the Act implies, it includes rooming accommodation. There is the Client Contact Centre available on 1300 366 311, where customers can seek assistance. So what is this Act all about, and where are disputes considered? Now, the matters of disputes involving residential tenancy agreements are heard by the Queensland Civil and Administrative Tribunal, QCAT, but in an entirely different way and a different, if you like, division to that which involves disputes such as building disputes or retail shop lease disputes. So in QCAT there are various divisions. The disputes in relation to residential tenancies are heard in the minor civil disputes jurisdiction, which used to be the small claims jurisdiction, and it's the people hearing those disputes are adjudicators and magistrates in the regional areas. So not the members of the tribunal. The members don't hear the residential tenancies disputes, but do hear retail shop lease disputes. So, and when there's a common misconception about the monetary limits in QCAT, yes, they certainly do apply 25,000 in the minor civil disputes jurisdiction, but it's the whole other range of matters heard in the tribunal that are not minor civil disputes. So when we're talking about residential tenancies, just be aware that if you look at a case, you'll see that it might be, if it's reported, it might be heard by a magistrate sitting in the minor civil disputes jurisdiction, or an adjudicator, which is directly, if you like, employed by QCAT. The difference is that we don't have adjudicators, I guess I'm speaking from the tribunal's perspective now, around the state, so we use magistrates to make those residential tenancy type decisions. When I read legislation, I tend to look at the objects and the purpose provisions. I look at the overall headings, and then I think about the operation and application provisions of an act. So it's always very important to me to have a good understanding of where disputes are heard and by whom. So I've mentioned the role of QCAT in its minor civil disputes jurisdiction in that regard, but I'd like you to have a look at Part 4 of the Act, which deals with application and operation. Now, there are two primary divisions in that part. And the first division relates to matters relating to residential tenancies and rooming accommodation. And the second division relates to residential tenancies agreements to which this Act applies and does not apply. So again, we're talking about the issues of application and operation. So looking at the first division in Part 4, you'll see that it caters for sections 18 to 28 inclusive. The one that caught my eye was section 27. And section 27 says that the Property Law Act 1974 does not apply to residential tenancy agreements. So whilst I'm saying to you that there is no question on the examination in relation to residential tenancies, what we must impress upon you is that if you were to refer to or rely upon something in the Property Law Act in answering a residential tenancies dispute question, you would be severely penalised by the examiner. So the Property Law Act does not apply to residential tenancy agreements. And you would have noted, by contrasting that to, say, the Retail Shop Leases Act, there is no such provision about the non-applicability of the Property Law Act in the Retail Shop Leases Act. Quite the contrary, the Property Law Act still applies in relation to in relation to retail shop lease disputes, even though there is the overriding Retail Shop Leases Act. I mentioned that as a contrast. But subsection 2 of section 27 of the Act says, unsurprisingly, nothing in subsection 1 affects the application of the Property Law Act to an agreement about a tenancy if the agreement is not a residential tenancy agreement. So again, we need to go back to the definition and have a clear understanding of what is meant by a residential tenancy agreement. Once we've ascertained that it is such an agreement, then we further conclude that the Property Law Act has no application. Which then means by default, when we're looking at resolving a dispute in relation to a residential tenancy agreement, we look to the Residential Tenancy and Rooming Accommodation Act almost exclusively, and the disputes are heard in QCAT in its minor civil disputes jurisdiction by an adjudicator or magistrate. Are we fine so far on the issues of jurisdiction and operation of the Act? Let's have a look at Division 2 of Part 4. The heading is Residential Tenancy Agreements to which the Act applies and to which it does not apply. Sections 29 through to 41. Section 29 deals with when the Act applies to certain residential tenancy agreements, and I'll leave you to read that. What I do like about some of these sections is they provide examples, which are always a great way to understand the application. Now, having determined that, let's just backtrack a moment and look at the objects of the Act. The objects contained in Section 5 are in two main parts. The subsection 1 talks about the main objects, which are to state the rights and the obligations of tenants, landlords, and agents for residential tenancies. I said landlords, I should have used the word lessors. Now note the difference in terminology. When we were talking about the Retail Shop Leases Act, we were talking about lessees and lessors. Now for some reason, and I'm really not sure about the reason, the rationale behind this, when we're talking about residential tenancy agreements, suddenly we're talking about tenants and lessors. I would have thought, but maybe landlord is kind of an objectionable term now because it's, amongst other things, it's very old-fashioned and maybe it's perceived as being a sexist term. So we have this sort of odd mix of tenant and lessor. They don't really match. It's a bit like mixing vendor and purchaser with buyer and seller. One goes with the other, then we're not mismatching. Anyway, just a small point. The second object contained in Section 5 talks about the way in which the objects are achieved by regulating the making, the content, the operation, and the ending of residential tenancy agreements and rooming accommodation agreements, providing for the resolution of disputes about those agreements, providing for the authority to receive, hold, and pay rental bonds, and providing for compliance, monitoring, enforcement, and the establishment powers and functions of the authority. When we look at this type of leasing arrangement, residential tenancies, there is a fundamental difference, isn't there, between it and commercial leases, commercial retail shop leases on the other hand, apart from the jurisdiction of where the Act and where you resolve the dispute. The other is this common thread in residential tenancy agreements for rental bonds. You would have noticed in commercial arrangements there is no rental bond authority. There might be a bond that is payable, but that's a private arrangement between the lessee and the lessor in a commercial sense. So if you're dealing with a commercial lease, you don't pay the bond to a rental bond authority. That's certainly the case in residential tenancies. Have a look at Section 12 of the Act, which talks about this key concept of a residential tenancy agreement. We know that's important because of the provision that I mentioned at the start, Section 27, which talks about the applicability or non-applicability of the Property Law Act. So what is a residential tenancy agreement? Section 12 says that it is an agreement under which a person gives someone else a right to occupy residential premises as a residence. It applies whether or not there is a right of exclusive occupation, and it applies whether or not the agreement is in writing, wholly or partly, or it's express or implied. Whether it's in a form mentioned in paragraph A or not. An agreement is, in subsection 4 says, an agreement is not a residential tenancy agreement if it's a rooming accommodation agreement, but an agreement is a residential tenancy agreement if it's taken to be a residential tenancy agreement under Section 18. So you need to then look at Section 18. But before we do that, we'll look at Section 13, which talks about a tenant. So a tenant is a person to whom the right of occupancy of a residential premises under a residential tenancy agreement is given. And again, you'll see there's referenced in an example to the Acts Interpretation Act, Section 35A, which talks about a person as lessee, including a reference to their personal representatives, successors, or assigns. A tenant includes the person to whom the right of occupation is given and a subtenant of the tenant. Have a look at Section 11 that talks about residential tenancies as a right to occupy a residential premises under a residential tenancy agreement. And then look at Sections 15 and 16 that deal with rooming accommodation. So a rooming accommodation is accommodation where someone can occupy a part of a residence, if you like, in return for payment of rent, and they have the right to occupy one or more rooms, but not the whole of the premises, not a self-contained unit, and they share the rooms with others. So a boarding house, for example, is a prime example. Section 16 talks about the rooming accommodation agreement. And again, it says an agreement is not a rooming accommodation agreement if it is taken to be a residential tenancy agreement under Section 18. So again, just look at Section 18 of the Act, which provides further clarification in that regard. And it's headed opting in as a residential tenancy agreement. Apart from that, I'd refer you to way down in the Act, Chapter 5, which talks about dealing with ending of agreements, sections 277 through to 396. And note, in particular, the process by which the provider can give notice of remedy to breach to a resident. And Chapter 6 deals with dispute resolution, which is conciliation, and tribunal hearings, which is through QCAT. Have a look at Section 414A of the Act, which talks about making applications to the tribunal, and it simply says that an application to the tribunal under the Act must be made in a way prescribed under the QCAT Act, and the application is dealt with by adjudicators or magistrates as the case may be. Now, I indicated to you that this would be a quick session, and I meant at that time. So that's all that I propose to talk to you about tonight in relation to this very important but non-assessable area of land law. I mentioned that I'm well advanced in the second assessment feedback. I'll just mention that the feedback that I provide will be of an entirely different manner. It's an entirely different style of feedback this time. I have chosen not to use the red pen type feedback, which can get a bit tiresome, I think, just seeing these negative comments and changes. So whilst I'm not providing you with a model answer by any means, I'm providing you with the sort of notes that I usually retain just for myself as a guide when I'm marking others' assessment. So this time, I'm giving you my material and I'm not giving you your paper back with the red marks in it. So I'm essentially giving you my material, and then at the end, I'm saying, in relation to your paper, and I've maybe highlighted a few things, and then I've given you basically where it fits, whether it's a HD or a pass or somewhere in between, or maybe a fail. So there's a whole range of marks, and I've identified where yours fits in. I haven't specifically said whether it's a high credit or a low credit or whatever, but you can see that from the marks. And I think you know that a pass mark is essentially 49.5 through to 64.5. A credit is 65 to 74.5. A distinction is 75 to 84.5. and a high distinction is 85 upwards. Less than 49.5, of course, is a fail. So I've indicated where you fit, and you can tell from the mark whether you were at the high end of that category or low end. So there's not a lot of specific material about your individual paper, but please read my notes carefully, and from that, hopefully you'll be able to identify why you fit within the category that I've assigned to you. And I hope to release that tomorrow. Are there any questions about that assessment regime or that approach to marking, or any questions about what we've talked about tonight? Yes, Scott?
Yeah, just one thing, John. You said that with the Section 27, it doesn't apply to the Property Law Act doesn't apply to residential tenancy agreements. So it would apply to those rooming accommodation agreements then?
That's a very good point. I hadn't considered that. Let's have a look at Section 27, and I'm just wondering if Section 27 only deals. That's a very good point. No, it doesn't say anything about rooming agreements, but I wonder if there's a counterpart provision that I haven't seen in the Act under the heading of rooming accommodation agreements. There may be a similar provision in relation to that. We'll just have a look at the, no, Part 4 talks about application and operation of the Act generally. Sections 43 and 44 deal specifically with the issue of rooming accommodation agreements. So on the run, I'll just see if there's something in there that might assist. I can't see it in 43, and I don't think I can see it in 44. So I'm sorry, I can't answer that one, Scott, but it's a very good point. That's very, very astute to pick that up. I'd like to be able to answer all the questions, but I can't. Sorry.
You can't know absolutely everything, John.
Thank you, Scott. Any other questions, comments?
Hi,
yes,
John.
Monique.
It's Monique. Just wondering, I'm about to start revision for the exam, and I'm wondering if you'll be providing any more specific revision over the coming weeks, like some tips.
I will. Yes. So what I hope to do tomorrow also, or over the weekend, is provide you with a more specific examination guide, which I like to do in week 10. So it'll be at the tail end of week 10 this time, sorry. I will give you a tip that you'll need to, that's in two parts, the examination. The first part is a compulsory question. From memory, that's worth 20 marks. And then I think there are 3 out of 4 questions for part B, again from memory. Each of those worth 10 marks to a total then of 50. So you must answer the 20% question, and then you get to choose 3 out of the 4 to make up to the 50%. For the 20% question, look very carefully at the 2 topics that we'll be finishing with, easements and mortgages. So next week and the week after are important for the exam. Other than that, with the exception of what we've talked about tonight, every part is assessable. I hope that helps, but I will formalise that. Thank you, Monique. Good question. Any other questions, comments? We'll ask one favour of you generally, and that is please provide some feedback. I see that some have already done so. It's very important for me, it's very important for all of your lecturers to have feedback. We really appreciate it. The university needs it. And if you would be kind enough to spend some time to provide feedback, I'd appreciate it. And I'm sure your other lecturers would do that as well. Okay, all good? All right, well, we'll keep in touch, and we'll see you next week for, I think, easements from memory. Okay, all the best. See you then.